12 northern states in Nigeria have operated under Sharia law for over 2 decades, and in all that time, not a single federal government has done anything to reverse it. Now here's the part nobody's asking. Is Sharia law in Nigeria actually getting stronger, not weaker? And does the Nigerian state even have the power to stop it if it wanted to? Because everything you've heard about this debate, the constitutional arguments, the religious tensions, the international pressure, it's all missing the one layer that actually explains what's happening. Stick with me. Before we go deeper, if you're just finding Niger News Feed, welcome. This channel exists to break down what's really happening in Nigerian politics without the noise, without the spin. Hit subscribe and stay with me because this one gets interesting. Let's go back to 1999. Nigeria returns to democracy after decades of military rule, and almost immediately, within months, 12 northern states begin adopting full Sharia penal codes, not just personal law for Muslims, criminal law, amputation, stoning, public flogging. The trigger was political, not religious. State governors facing restless populations and weak economies saw Sharia as a legitimacy tool. I am a Muslim governor. I will give you Islamic justice. It worked. Electorally, it worked immediately. Fast forward to today. The reason this conversation is alive right now is because you have 3 things colliding at once. A constitutional review process creeping forward in the National Assembly, a new wave of Sharia court judgments, including death sentences, attracting international attention, and a political class in the north that is increasingly using Islamic identity as a shield against federal accountability. This isn't just a religious question. It never was. It's a question about who controls the north, who controls resources, and whether Nigeria's federalism can survive the pressure it's under. Here's the architecture, and it's deliberately messy. Section 10 of the Nigerian Constitution says no state shall adopt any religion as a state religion. That is clear. On paper, Sharia penal codes operating as state criminal law in 12 states appears to violate that clause directly. But here's where it gets complicated. Section 277 of the same constitution establishes the Sharia Court of Appeal and gives it jurisdiction over personal Islamic law. The argument from northern governors has always been, we're just expanding what the constitution already permits. We're not declaring a state religion. We're giving our Muslim citizens access to their own legal tradition. That argument has never been seriously tested in the Supreme Court, and that's not an accident. Every federal government since 1999 has refused to allow that case to be heard because the political cost of a ruling, either way, is enormous. The gray area being exploited is this: personal law versus criminal law. The Constitution allows the former. The 12 states are operating the latter. And as long as no one with standing takes it to the Supreme Court and forces a ruling, that ambiguity is the entire ballgame. This is the part that changes everything. Who benefits? Let's be precise. Northern governors benefit. Sharia law in the north is, among other things, a deflection machine. When people are angry about poverty, insecurity, and a collapsing education system, and they are, Sharia governance gives them a moral framework to blame. The conversation shifts from, why hasn't the governor fixed the roads, to, are we being sufficiently Islamic? That is a powerful political tool. The traditional northern elite, the emirs, the district heads, the Sufi orders, benefit from a parallel legal system that insulates their authority from federal oversight. Sharia courts in some states are dispensing judgments on land, inheritance, and commercial disputes that would otherwise go through federal structures. That's enormous informal power. Now, who loses? Christian minorities in the north, obviously, but also Muslim women who bear a disproportionate weight of Sharia penal enforcement. Multiple studies and human rights reports have documented this. The famous Safiya Husseini and Amina Lawal cases, women sentenced to death by stoning for adultery, attracted global outrage. They were eventually acquitted on procedural grounds, but the structure that produced those verdicts is still fully operational. Here's the silent player nobody talks about: the federal government itself. Abuja has been using the Sharia arrangement as a bargain. Northern political support, which is critical to winning the presidency, is purchased partly through federal non-interference in northern state governance. This is a transactional silence. Tinubu's government inherited it. Every government before him operated it. The electoral implication is stark. Any national politician who openly calls for the dismantling of Sharia courts in the north is immediately unelectable in 12 states. That's not a religious statement. That's an electoral arithmetic statement. And here's the regional asymmetry. Southern states operate under common law inherited from British colonial administration. Northern states operate a hybrid of common law, customary law, and Sharia, with Sharia increasingly dominant in criminal matters. This isn't just a cultural difference. It creates two parallel systems of justice, two parallel systems of land tenure, two parallel systems of commercial law. For any business wanting to operate across Nigeria, that is a structural problem. Now, if what I just laid out surprises you, drop a comment below. I want to know your take before we get to the part that changes the whole picture.
Pull back the camera for a moment, because the national picture is darker than the headlines suggest. On federal-state balance, Sharia governance has functionally expanded state power in the north beyond what the Constitution intended. States are running parallel courts, parallel penal systems, and in some cases, parallel security structures in the form of Hisbah police. When a state has its own moral enforcement agency, it is operating territory that the federal government has conceded. That's not federalism, that's fragmentation. Economically, the consequences are significant. Foreign investment in the north, outside of extractive industries, is structurally limited by legal uncertainty. If you're a foreign company and you don't know which court system will resolve your commercial dispute, you don't invest. The North's economic underperformance relative to the South is not solely caused by this, but the legal duality is a contributing factor that is almost never discussed in those terms. On interfaith relations, the North is not monolithic. There are large Christian minorities in Kaduna, Plateau, Benue, states that border the Sharia belt. The recurring violence in those areas is not purely religious. It's a conflict over land, over political representation, and over whose legal framework governs disputed territory. Sharia expansion doesn't cause that conflict directly, but it provides a political grammar that inflames it. Security implication. Any movement toward renegotiating Sharia governance, which a constitutional review could force, risks being exploited by groups like Boko Haram and ISWAP, who have always framed their insurgency as a defense of northern Islamic identity against southern federal encroachment. That threat is a real constraint on what the federal government can do, and it knows it. There is a genuine international dimension here, and it cuts in more than one direction. Western governments, the US, UK, and EU, have repeatedly raised concerns about Sharia penal enforcement in Nigeria, particularly in relation to freedom of religion and women's rights. The U.S. State Department's annual International Religious Freedom Report has flagged Nigeria consistently for years. The practical consequence is not sanctions, it's reputational friction that affects foreign direct investment and bilateral relations. But here's the counterweight. Gulf states, Saudi Arabia, UAE, Qatar, have significant financial relationships with northern Nigerian institutions. Islamic education, mosque construction, and scholarships flowing from the Gulf have expanded the social infrastructure of Sharia governance in the north. This is soft power operating in the exact opposite direction from Western pressure. Lagos faces one set of international expectations. Kano faces another set of international incentives. That's a real structural tension. For the diaspora, Nigerians in the UK, US, and Canada need to understand that when they pay taxes to their host governments, those governments are navigating this tension too. because Nigeria's stability is directly tied to West African security and migration patterns that affect European politics. This is not just a domestic Nigerian debate. It has ripple effects that reach the offices of foreign ministers in London and Washington. The global pattern. Nigeria is not unique. Countries with large Muslim populations operating under hybrid secular religious legal frameworks, Indonesia, Pakistan, Malaysia, all face versions of this tension. The question is always the same. Can a modern federal state sustain legal pluralism without it becoming a vector for fragmentation? Nigeria is the highest stakes version of that question in the world right now. Let me push back on the three most common narratives you'll hear, because they all contain a partial truth that hides a bigger distortion. Misconception 1. Sharia is purely a religious matter and the federal government has no business interfering. The truth is, religion and governance are not separable once you're running criminal courts and enforcement agencies. The moment a Hisbah officer arrests someone for a moral offense, that is state power being exercised. The Nigerian constitution governs the exercise of state power. Full stop. Misconception 2. This is a northern versus southern problem. The reality is more nuanced. There are fierce debates within the north between modernist and traditionalist Islamic scholars, between governors who use Sharia rhetorically and those who take it literally, between urban middle-class Muslims who want secular courts for commercial life and rural communities where customary and Islamic law are deeply embedded. This is not a monolith. Misconception 3. If Nigeria were properly secular, this problem would go away. The strongest counter-argument here is practical. Secularism in Nigeria has never been a neutral force. It has historically reflected southern political dominance, and many northern communities experienced colonially imposed common law as a cultural erasure. The demand for Sharia is partly a demand for self-determination. That's a legitimate political claim, even if the implementation creates serious problems. Where does that argument fall apart? It falls apart when legal self-determination is used to exempt powerful actors from accountability, or when it produces penalties, stoning, amputation that constitute cruel and degrading treatment under international human rights standards that Nigeria itself has signed. Self-determination is a principle. It does not override all other principles.
So, what happens next? Let me give you the three scenarios and the signals to watch for. The most likely scenario, which I'd put at around 60%, is continuation of managed ambiguity. Abuja continues to not challenge Sharia governance in the north. The 12 states continue to operate as they do. The constitutional review process produces cosmetic adjustments at best. The federal government gets northern political cooperation in exchange for continued non-interference. This is the status quo operating system, and it has been remarkably durable. The second scenario, maybe 25% probability, is escalation through a crisis. This would be triggered by either a Sharia judgment that produces an international incident too big to ignore, an execution that goes viral globally, or a security crisis in a Sharia state that forces federal military intervention, which then creates a constitutional collision between federal authority and state governance. Watch for any foreign government issuing a formal diplomatic protest over a specific case, or any federal deployment into a Sharia state that includes confrontation with Hisbah forces. The third scenario, the 15% that nobody in Nigerian politics wants to talk about, is that a constitutional review process actually produces a legal challenge that reaches the Supreme Court. If the Supreme Court rules that Sharia penal codes are unconstitutional, you would have a legitimacy crisis in 12 states overnight. If the Supreme Court rules they are constitutional, you have permanently legitimized a parallel legal order. Either ruling reshapes Nigeria. Watch for any state attorney general filing a formal challenge or any Supreme Court judge making public statements about the court's readiness to hear such a case. The long-term impact if nothing changes. The gap between northern and southern governance, economics, and legal culture continues to widen. The prospects for a genuinely integrated Nigerian national identity, which was always a project under construction, become harder to sustain. That matters not just for Nigeria, it matters for the stability of West Africa's most populous and economically significant country. So, back to the question I opened with. Is Sharia law in Nigeria getting stronger, not weaker? And does the Nigerian state even have the power to stop it if it wanted to? The honest answer is, institutionally, yes, it's getting stronger. Not because Nigeria is becoming more religious, but because the political incentives that sustain Sharia governance have not changed and in some cases have deepened. The federal government has the constitutional authority to challenge it. What it doesn't have is the political will, because the electoral cost is too high for anyone currently in power to pay. That is the answer, and it's an uncomfortable one, because it means this issue will be decided eventually, not by theologians or constitutional lawyers, but by the same forces that created it: political calculation, electoral arithmetic, and whoever ends up holding power in Abuja when the next crisis forces a decision. I want to know your take. Are you optimistic that Nigeria finds a way through this, or do you think the structural gap is now too wide? Drop it in the comments. I read everything. If this breakdown gave you clarity on what's really going on, do me a favor, share it with one person who needs to understand this. Like the video, subscribe to Niger Newsfeed, and I'll see you in the next one. Stay sharp.